go find the rest of my group members.
Good.
Oh.
Hi, Jazmine.
Charmiane.
Is that Bree? Hi, Bree. Pramira, come on. I finally found you. Everyone's waiting. Let's go.
Men, reporting for duty.
Where are you?
My name is Lee. Nicole Lee.
Oh, it's you, it's Nicole. You're fired.
Excuse me, ma'am, but why?
There seems to be some complaints about you regarding your poor performance. Now, get out of my office.
This is highly unfair. I'm gonna sue you, man.
Good luck with that. I have immunity.
Dr. Lee, I fired Agent Nicole. She knows too much about Operation La La Land. You know, us giving up weapons and taking their money. But she wants to sue us for her unfair dismissal or something.
Do not fear, they have immunity against whatever she's suing us for.
Have you ever wondered what do the higher authorities mean when they say that they have immunity?
Public interest immunity used to be known as Crown privilege. This immunity revolves around common law to allow the refusal of evidence disclosures as it would be damaging to public interest. When public interest immunity is applied, it excludes relevant evidences from the production in court. Under the Crown Proceedings Act 1947, it was expressed that the disclosure of documents in the interest of justice may be ordered by the courts. However, in Section 28, it provides that this power was only extendable to civil proceedings. Principally, it is deemed that the act is inappropriate in criminal cases as opposed to civil cases. This is because, in criminal cases, the right to silence remains paramount. Thus, if a criminal trial becomes apparent that there is a duty to disclose sensitive, unused materials that would harm the public interest, the most likely outcome is that the materials would not be required to be disclosed. The general rules in terms of disclosure of public interest immunity in criminal trials can be seen in the case of Regina against Brown by the Court of Appeal, as the court states that for present purposes, there are 4 propositions which are to be established. Firstly, it is up to the discretion of the court to issue the immunity. Secondly, the judge has to perform a balancing exercise between the public interest and the interest of the defendants. Thirdly, the balancing exercise should be reconciled with a defendant's fundamental right to a fair trial. And fourthly, despite their judge initially deciding against disclosing it, under a continuous duty whereby the trial develops, the decision is technically still under review. Over the years, despite still being limited, the use of public interest immunity in criminal cases has increased due to the House of Lords having a more open view towards it. For example, in the case of Regina against Governor of Brixton Prison, ex parte Osman, in 1991, which involved an application for habeas corpus, Lord Justice Mann noted the absence of any definitive pronouncement in the early authorities about whether Crown privilege was applicable in criminal proceedings. He also referred to the decision of the Supreme Court in the case of Regina against Robertson ex parte Mac Ole in 1983, which states public interest privilege as now defined in Conway and Rimmer regards Crown privilege in criminal cases as being governed by similar principles as the general law. However, he also acknowledged that in the case of criminal proceedings, there is the importance that public interest in administration of justice should not be frustrated by the withholding of documents that might assist an accused person to establish his innocence.
Also, in terms of national security, it can be seen in the case of Al-Swidi against Secretary of State for Defense in 2009. The claimant sought that a court order on the number of Iraqi deaths linking to the allegations of serious mistreatments by British soldiers should be independently investigated. There were allegations of British soldiers murdering, torturing and mutilating Iraqis after the battle, which is also known as Danny Boy in 2004. Disputes of facts between the parties gave rise to the need for the Ministry of Defense to consider the disclosure of the materials. A Ministry of Defense minister subsequently signed a public interest immunity certificate which claimed that the disclosure of the documents would not be in the public interest for reasons of national security. However, since some of the documents were already in the public domain, as it was disclosed in an earlier court-martial proceedings, the Ministry of Defense agreed that the materials should be disclosed to the participants in a public inquiry. The court was sharply critical in its judgment, describing it as lamentable that the integrity of the public interest immunity system should have been compromised in this. This shows that parties to litigation and the courts themselves have appropriate access to national security information depending on the court being able to have confidence that what the government claims in a public interest immunity certificate is accurate and reliable. It also shows that court will not always have that luxury. The concern here is that sometimes the government will make a mistake as the operation of a claim to public interest immunity cannot be properly checked and assessed within the department. This often leads to a number of administrative reforms designed to address the systematic failures in the Ministry of Defense, which Al-Swidi identified and of which the court was sharply critical. Furthermore, sometimes officials will act, be it deliberately or carelessly, to undermine the system. All three occurred in Al-Swidi. That is, there were mistakes, systematic failures of public administration, and the individual actions which made matters even worse. These issues came to light only because of the persistence of the claimant's legal team. Apart from that, reports from the Joint Committee on Human Rights and the Human Rights Watch, it is often repeated that when it comes to torture and the war on terror, the issue for the United Kingdom is not the treatment which it has meted out for itself, but its complicity in the treatment which has been meted out by others. Another public interest immunity misuse is seen in the case of Matrix Churchill Engineering. Here, the British government were charged because they were producing firearms for the Iraqi government, in where the ministers of the Crown has affirmed their immunity by signing a public interest immunity certificates, which validates the fact that defendants might have been secretly involved in an immoral or illegal act of the respective authorities. In regards to this, an inquiry surrounding this whole incident was ordered by the Prime Minister, which then Lord Justice Scott conducted. A letter to the newspaper company was written by the Attorney General regarding the conduct of the trial. This letter held that ministers were supposed to sign a certificate and that what happened consisted of the careful application of well-established procedures designed to ensure that proper balancing by the court of competing public. As mentioned earlier, mistakes are susceptible to occur during the operation of a public interest immunity claim, as it would not always be properly checked and assessed. Therefore, it can be seen that the public interest immunity prevails in the criminal proceedings, and a concern on the rigidity of being able to disclose necessary information may arise.
On the other hand, the Official Secrets Act 1989 protects UK against espionage and prevents sensitive government information from disclosure, covering offences like sabotaging, spying, and disclosure of sensitive information by employees and ex-employees of security services. A case concerning governmental censorship is seen in the case of R and Secretary of State for the Home Department ex parte Brian, where a judicial review was sought due to prohibition of broadcasting of speech by representatives of terrorist organizations. The directives were challenged on illegality and incompatibility with the ECHR. However, it is held that the restrictions imposed were necessary in public interest to combat terrorism. In the case of Bryant, it is observed that attempts on restraining political information provides an interesting microcosm of constitutional problems, and it's essential a balance between access to and protection of personal or official information proceeds to plague British administrations. This leads to broader concerns on the liberal concept of a positive notion of government with the full citizenship it requires. OSA's operation should be limited and not act as a shield to protect provisions' literal wordings. It shouldn't be invoked unnecessarily or for unimportant considerations when there are other suitable laws available, as its purpose is to punish espionage, gross breaches of trust and carelessness with regards of state secrets. Moreover, law will become oppressive if OSA was used unreasonably and frequently, as it will stifle the exposure of government inefficiency and corruption.
Up until today, it is seen that the withholding of information, be it documents or photos, infringes a person's right to a fair trial, as stated in Article 6 of the European Convention on Human Rights (ECHR) in the name of public interest immunity. Aside from that, Article 8, right to privacy, can also be used regarding the information disclosure. The European Court of Human Rights asserted that prosecution should disclose all evidence for or against the accused to ensure equality. They agreed that this wasn't an absolute right, as there may be situations where withholding information can be justified under public interest, and the domestic court could decide whether non-disclosure was needed. The Supreme Court had to balance both the interests of justice and children's welfare in Re A Child 2012. The issue was whether the identity disclosure of the father's accuser, which is his daughter, and the substance of allegations against him should be given to the parties, and whether there should be a requirement for the daughter to give evidence in those proceedings. Serious sexual abuse allegations were made by the daughter towards the father to social workers. Public interest immunity was claimed by the local authority, but the Court of Appeal reversed the decision, thus ordering a disclosure. It's clear that the daughter's right to privacy and the prevention of inhumane or degrading treatments was suppressed by the father's right to a fair trial. The decisions made despite the statement from the National Society for the Prevention of Cruelty to Children, the NSPCC case, which ensures that anyone with information about children's abuse to come forward is a public interest. So although under Article 8, everyone has a right to private life, when it comes to circumstances concerning matters like national security, he or she's right under Article 8 will be breached so that another person can exercise their right to a fair trial. This brings about the debate of should vulnerable people who provide information on alleged abuse be entitled to public interest immunity. Moving on, governmental disclosure is also done via Freedom of Information Act 2000, allowing the public to access information held by public authorities. The principle behind FOIA is that people have the right to know what the public authorities are doing. A requester isn't required to provide reasons on why they want the information, but public authorities have to justify why the information is being refused. However, it's subjected to certain exceptions. Qualified exemptions require authorities to examine the balance of public interest before deciding on the disclosure or withholding of information through the public interest test. An important factor for the public interest test is time. In Upper Tribunal, in APPGER and ICO and Foreign and Commonwealth Office, the situation at the time of request should be taken into account by the public authority. The arguments raised during the test are frequently irrelevant and shouldn't be used to weigh the balance, as mentioned in Christopher Martin Hogan and Oxford City Council and Information Commissioner. These factors include the identity and private interests of the requester, and or on the basis that the information is technical and complex that it might be misunderstood. There are also situations where absolute exemptions are concerned. For example, where decision makers don't need to scrutinize public interest in disclosing the information, with the exception of Section 41 of the FOIA. There are 8 absolute exemptions where the public interest test isn't applicable. Personal information, information under parliamentary privilege, and those concerning the public affairs conduct in the House of Lords or House of Commons come under this exemption too. Additionally, absolute exemptions also include when an actionable breach of confidence is resulted from the information disclosure or if it's prohibited by other enactments, community obligations, or court's contempt. In Section 2 of the FOIA, there's a reverse emphasis that creates a presumption in favor of disclosure. This implies that if there's an equal balance, the public interest should prevail. It should also be noted that a public authority's application of the public interest test can be overruled by the Information Commissioner and form his or her own view on its balance. Nevertheless, the Commissioner's ruling can be vetoed by relevant ministers under Section 53 of the Act. The relevant minister would then issue a conclusive certificate supported by reasonable grounds that in his or her opinion, the public interest doesn't outweigh the exemption claim. In such cases, the commissioner or the complainant has the option to seek judicial review on it. In conclusion, it can be seen there's an ongoing struggle between the conflicting articles under the ECHR as well as on the debate whether vulnerable people who provide information on alleged abuse be entitled to public interest immunity. Furthermore, after identifying arguments for and against the disclosure, it can be seen that there is no exact process as to how the disclosure of information should be conducted. Hence, since the nature of this subject is still subjected to a certain extent, there is still a possibility of malpractice. Therefore, the Commissioner has to, as objectively as possible, evaluate the weight of these arguments to determine the balance between the public interest and disclosure of information.
Now, we'll be moving on to the evolution of public interest immunity.
Civil servants are now more reasonable and inspired by ideology. Furthermore, it is highlighted that the historical factors help determine the innate instinct for secrecy on the part of the executive, as the courts were more daring to challenge the government when it comes to claims for suppression of materials at trial. Since the 13th century, the rule was that the Crown was not allowed to sue in its own court. When the hardship of this rule was elevated by the development of the rights petition as means of proceeding against the Crown, the maxim that the king can do no wrong prevented that remedy from being accessible in tort. However, in 1921, a Crown Proceedings Committee was arranged and subsequently a draft bill was produced, where the main purpose was to put the Crown in the same litigations as any other public authorities, as the Crown should bear its fair share of legal liability when a wrong is done. In the year of 1946, attention was drawn by the House of Lords in the case of Adams and Naylor, and the Court of Appeal in Royster and Cavey on the unsatisfactory state of affairs, and a bill, Crown Proceeding Act 1947, was then introduced by Lord Chancellor. Section 28 of the Act enabled the courts to order for discovery of documents and require answers of interrogatories from the Crown, but it would be subjected to a few important exceptions where, as stated in Section 28, subsection 2, the disclosure of contents would be damaging to the public interest. For instances, endangering public security, prejudice diplomatic documents, and where production would be restrained to ensure the proper functioning of the public service. In scenarios where such exceptions occur, the withholding of documents and refusal to answer questions are allowed. The former exception was confirmed in the case of Duncan and Camel, where in the year of 1939, a submarine built by the respondents sank during the emergent tests. As a result, 99 lives were taken and the family of deceased brought actions for negligence. They seek for disclosure of documents of the submarine's construction but was objected by the respondents, and a claim for Crown privilege was submitted as the disclosure of the documents would be injurious to the public interest. It was held by the House of Lords that even when the Crown was not a party to the proceedings, the documents should not be disclosed if it is required by public interest to be withheld. At the same time, it was agreed uniformly by the House of Lords that a claim of Crown privilege made in proper form could never be questioned, notwithstanding the document's nature, which is applied to both the contents and the classes of the documents.
Ministers of the Crown are the only arbiters of public interest, and if an objection of a document's production was taken in a proper manner and formed by a minister after personal scrutiny or by the permanent head of the department in the minister's absence, its production would be against the public interest as stated in certificate or affidavit of the court is obliged to accept it as a final, definitive decision. The House of Lords also accepted that the minister's opinions need to be given weight and taken into account as well. Nevertheless, the question on whether the courts will be prepared to exercise their judgment by balancing interests of the minister against the interests of disclosure arises, and it seems that some classes of documents ought to never be disclosed. For instance, in the case of Attorney General and Jonathan Cape, where a diary of cabinet discussions and events were kept by the cabinet minister with the intention to publish the contents of it. After the passing of the minister, the first volume of the book was sent for approval but got rejected by the Secretary of the Cabinet as it was against public interest. But the first extract of the book was eventually published without the Secretary's consent. It was held that the doctrine of collective cabinet responsibility was appraised by Lord Widgery at certain length, where it concludes that the maintenance of the doctrine was in the public interest. Therefore, it justifies the grants on restraints on the cabinet's discussions disclosure. However, public interest does not require such restraints in the present cases by the court because the recording and disclosure of such events had elapsed for 10 years. Hence, future operation of collective responsibility would not be prejudiced and free discussion in cabinet would not be inhibited.
Conversely, Conway's case showed opposing views of Duncan's case. The House of Lords established the consensus that the courts, not the Crown, had the final say in whether a claim of public interest immunity succeeded, and held that the courts were entitled to exercise a power and duty to hold a balance between the public interests. Alas, this consensus did not mark the end of excessive claims for public interest immunity. In practice, this is thought to have led to a reduction in the number of cases when public interest immunity is asserted. Lord Upjohn gave 3 reasons why Duncan's case shouldn't govern this case. Firstly, the House misunderstood European countries' law. Secondly, His Lordship didn't notice Lord Simon's observations were supposed to bind the courts to accept minister's certificate. Thirdly, courts were entitled to create a re-evaluation on regarding specific documents of what the general public interest demands. Therefore, it's determined they have reserved powers to examine documents, cover claims for privileges, and to individually judge who deserves such a claim. In an extreme application, this would cause calamity to state security and national safety. In Burma Oil and Governor and Company of the Bank of England, the company sought an order for discovery of all documents held by the bank relevant to the issues pleaded. The bank disclosed quantities of material relevant to the issues, but on government instructions restricted production of 62 documents in its possession and control. Objection to production was taken by the Chief Secretary to the Treasury, where he mentioned that the 62 documents listed in a schedule and had formed the opinion that their production would be injurious to the public interest. House of Lords has applied Conway to government activities. However, the judges in Burma Oil were divided on the degree of caution which should be exercised. This decision remains the most important decision on Crown privileges, particularly in government departments. However, public interest immunity isn't restricted solely to the Crown and can't be waived in exceptional circumstances. This concern is further explained in D and National Society for the Prevention of Cruelty to Children, where immunity is given to those that has provided information concerning to kids being ill-treated or neglected to the Neighbourhood Authority or NSPCC from revelation of their identity. This is almost like how the law allowed to inform the police in the case of marks and wafers. The allegation of D mistreating her child was investigated by the NSPCC and damages were claimed by D, where documents were sought from NSPCC to identify who made the allegation. The House of Lords upheld NSPCC's claim of public interest immunity as its legitimate role was to protect children's welfare, as seen clearly in public interest.
National security documents were also abolished by the government's announcement. This was unavoidable since evidence was given by the Security Services legal advisor to the Scott Committee. Class claims also undermines the credibility of security services. Looking at criticism of class claims in the Scott report and successful abolition by the central government, courts became more skeptical towards claims by other bodies, as was the House of Lords in Willie's case, which agreed that ministers have no duty to sign public interest immunity certificates, contrary to the assertion of the Attorney General and Matrix Churchill. The law of public interest immunity further evolved in the case of R. and Chief Constable of the West Midlands Police, ex parte Willie, which set out that in order for an application of public interest immunity to be made, it must first be considered whether the material is relevant to legal proceedings. Secondly, the public authority must consider if the disclosure would pose a real risk of harm to public interests. This assessment must be made based on the content of the material and not on what class of material is in issue. Thirdly, the public authorities are granted a general discretion to disclose documents where they judge to be in the overall public interest. However, the court is the ultimate decision maker, its assessment being the final stage of the process. Meanwhile, it can be said that the case of R. and Davis, Rowe and Johnson, or otherwise known as the M25-3 case, further refined the public interest immunity regime. The case has introduced 3 types of public interest immunity applications. For the first type, the defense will be told by the prosecution about the public interest immunity application and which category the material falls into. Then, the defense will make their own representations to the judge. Secondly, the defense will be informed about the application, but not the category of the material involved. Thirdly, in exceptional cases whereby to even reveal that an ex parte application was to be made, the hearing of that ex parte application could happen without notifying the defense that was involved. The procedure can be found in the Criminal Procedure and Investigation Act of 1996. However, it is arguable that despite the third procedure being included in the new rules, it has in reality been abolished in the case of R and H and C. This case represents the first domestic case that successfully relied on arguments for special counsel. In this case, the House of Lords had laid down a 7-stage test to consider public interest immunity applications. It is held that special counsel usage is only limited to exceptional cases, and it is not up to the courts, but rather the prosecution who would be the one who primarily decide on the issue of disclosure. The Criminal Justice Act 2003 Part 5 further evolved the public interest immunity process. The Crown can only initiate a public interest immunity application by disclosing materials that are considered to be able to undermine the case for the prosecution or assist the case for the defense. Then, the defense will be required to produce a detailed and descriptive defense statement.
In conclusion, even though the process of information disclosure has greatly evolved, there are still several contemporary and continuing concerns relating to the extent the government may be required to disclose information to the courts. Hence, statutes like the Freedom of Information Act and European Convention on Human Rights should be enforced Further, alongside with disallowing too many exceptions, as it will open up the floodgates of refusal of information disclosure by the government as to what the citizens entail.